Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, Fourth Amendment warrants, exceptions, and exclusionary rule. Let's begin. Fourth Amendment questions reward sequence. Do not jump to an exception before asking whether there was government conduct, a search or seizure, and a reasonable expectation of privacy or physical trespass into a protected area to obtain information. Do not jump to suppression before asking standing, a valid warrant, exceptions, causation, attenuation, independent source, inevitable discovery, and good faith. The best answer usually follows the chronology of police conduct. The Fourth Amendment protects people against unreasonable searches and seizures by the government. A search occurs when the government violates a person's reasonable expectation of privacy or physically intrudes on a constitutionally protected area to obtain information. A seizure of a person occurs when, by physical force or show of authority, the government restrains liberty and the person submits or is physically controlled. A seizure of property meaningfully interferes with possessory interests. A warrant is valid if issued by a neutral and detached magistrate, based on probable cause, and particularly describes the place to be searched and items or persons to be seized. Probable cause exists when facts and circumstances create a fair probability that evidence, contraband, or a person will be found in the place searched or that the suspect committed a crime. Standing. A defendant may challenge a search only if the defendant's own Fourth Amendment rights were violated. Ownership of seized evidence is not enough. Overnight guests usually have standing in the host's home. Purely commercial visitors or short-term visitors present only for a legal business usually do not. Warrant requirement. Searches inside a home are presumptively unreasonable without a warrant unless an exception applies. The home receives maximum protection, including curtilage. Open fields are not protected, even if fenced or posted. Particularity. A warrant must describe with reasonable precision the places and things. Officers may seize items in plain view if they are lawfully present and the incriminating character is immediately apparent. Execution. Police generally must knock and announce before entering a dwelling unless reasonable suspicion supports no-knock entry. Violation of knock-and-announce rules does not automatically require exclusion. Major exceptions. Search incident to lawful arrest. After a lawful custodial arrest, police may search the arrestee's person and areas within immediate control to protect safety and evidence. For vehicles, police may search the passenger compartment incident to arrest only if the arrestee is unsecured and within reaching distance at the time of search, or it is reasonable to believe the vehicle contains evidence of the offense of arrest. Automobile exception. If police have probable cause to believe a vehicle contains evidence or contraband, they may search the vehicle and any containers that may contain the object of the search. Mobility and reduced privacy justify the exception. Consent. A search is valid if voluntary consent is given by someone with actual or apparent authority. A present co-occupant's express refusal generally overrides another occupant's consent as to shared premises, but police need not seek out an absent objector. Plain view. Officers may seize evidence without a warrant if lawfully in the viewing area, lawful right of access exists, and incriminating nature is immediately apparent. Exigent circumstances. Warrantless entry or search may be justified by hot pursuit, imminent destruction of evidence, emergency aid, or risk to safety. The scope must match the exigency. Stop and frisk. Police may conduct a brief investigatory stop with reasonable suspicion of criminal activity. A frisk for weapons requires reasonable suspicion that the person is armed and dangerous. The frisk is limited to a pat-down for weapons, though immediately apparent contraband may be seized under plain feel. Inventory searches. Police may inventory lawfully impounded vehicles or booked arrestees' belongings under standardized procedures, not as a pretext for investigation. Special needs and administrative searches. Some searches without individualized suspicion are permitted when needs beyond ordinary law enforcement justify them, such as border searches, certain school searches, probation searches, and closely regulated industries. Exclusionary rule. Evidence obtained in violation of the Fourth Amendment may be suppressed in the prosecution's case-in-chief, along with fruits of the poisonous tree. Exceptions include independent source, inevitable discovery, attenuation, and good faith reliance on a defective warrant or binding precedent. Suppression generally is unavailable for grand jury proceedings, civil cases, parole revocation in many settings, and impeachment of the defendant's testimony. California criminal procedure may provide statutory rules for suppression motions, but MBE Fourth Amendment doctrine controls on the multi-state portion. California courts apply federal constitutional baselines after voter enacted limits on excluding evidence solely under broader state search-and-seizure grounds in criminal cases. California recognizes privacy interests under its state constitution in other contexts, but do not import those broader privacy principles into MBE Fourth Amendment questions. Note: on the California bar, if an essay expressly asks for California law, discuss federal doctrine first, then any California-specific statutory or constitutional overlay. For MBE, stay federal. Trap 1. Calling every police observation a search. Items knowingly exposed to the public, including garbage left for collection, public movements, and open fields, often lack reasonable privacy expectations. But long-term technological monitoring or sense-enhancing technology aimed at the home may be different. Trap 2. Forgetting standing. A passenger may challenge an unlawful stop of the car as a seizure of the passenger, but may not automatically challenge the search of the car's trunk or another person's bag. Trap 3. Overextending search incident to arrest in cars. After the arrestee is secured in a patrol car, search of the passenger compartment requires reason to believe evidence of the arrest offense is inside. Trap 4. Treating reasonable suspicion as probable cause. Stops require reasonable suspicion. Arrests and automobile searches require probable cause. Trap 5. Suppressing despite good faith. If officers reasonably rely on a warrant later found defective, evidence usually comes in unless the affidavit was knowingly or recklessly false, the magistrate abandoned neutrality, the warrant was facially deficient, or probable cause was so lacking reliance was unreasonable. Trap 6. Assuming Miranda fixes or breaks Fourth Amendment issues. Miranda is Fifth Amendment doctrine. A voluntary confession after an illegal arrest may still be fruit unless attenuation exists. A classic question begins with a traffic stop. Ask whether the stop was lawful. Any traffic violation gives probable cause for the stop regardless of subjective motive. During a lawful stop, police may order driver and passengers out, run checks, and use reasonable safety measures. Extending the stop for dog sniffing or unrelated investigation requires independent reasonable suspicion. Another pattern involves a house entry. Warrantless home entry is presumptively unreasonable. Look for consent, emergency aid, hot pursuit, or imminent destruction. Once lawfully inside, plain view may justify seizure, but not a general exploratory search. A third pattern tests fruits. Police illegally search, find a witness, obtain a confession, or later get a warrant. Ask whether the later evidence came from an independent source, would inevitably have been discovered, or is sufficiently attenuated by time, intervening circumstances, and flagrancy of misconduct. Attack sequence. Government action, search or seizure. Defendant's own protected interest. Valid warrant. If no valid warrant, exception. If violation is evidence fruit, does an exclusion exception apply? Exam payoff. Most wrong answers are too broad. The correct Fourth Amendment answer is narrow, chronological, and tied to the specific place, person, item, and police justification. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.